If you can please take your seats, we have a quorum. It is 5:50, and we have a hard stop at 6:50, which for those of y'all that have not been with us before, it doesn't sound like that long of a time, but for us, we need a lot more time than that usually. So we're going to have to move a little bit quickly. This is our very last hearing. All the bills on the calendar have been vetted either in subcommittee or with everyone that's been interested in the bills over the last couple weeks. So I know there's some that still want to be heard on some of these bills. And so we're going to move as quickly as possible, but make sure that we're getting it right. I will ask Chairman Dolezal, you want to open us up in a word of prayer? What mic are you, 15?
Yes, sir.
Y'all bow with us, please.
God, we thank you for the gift of today. It's a long day. Just pray that you would quicken our minds and allow us to get through this committee meeting and do your will for the best of your people in the state of Georgia. In your name we pray. Amen.
Thank you for that. All right, we're going to start with House Bill 268. I'm going to ask Chairman Calzert and Representative Persinger if y'all want to come down here. We are working off a substitute that has been I know a lot of work's gone into this. Also, there was a subcommittee last week. Chairman Cowles, you heard, 2.5 hours of testimony, I believe you said last week in sub, and you took,
That's right, Mr. Chairman.
took the comments you got and have worked with the House author to try to make sure we get the best bill possible, working off of LC 492396S. The floor is yours.
Thank you so much, Mr. Chairman. I'm going to tell you to start with, I am just unbelievably impressed at the time and energy and effort put into this bill from the House side, it being the Speaker's top priority. And Chairman Chris Irwin was one of the chief draftsmen, and it's just incredibly complex and detailed and really hits the high points of what I think the public's looking for and what we can do best to protect our students. Also greatly impressed with my friend Representative Holt Persinger, who represents Appalachia High Schools District, and it's very personal to him, and he has spent a lot of time and energy and has helped coach me up on it. I know that the House had 5 or 6 hours of hearings, and we had about a 2.5 hour subcommittee hearing, and what we present as our report is this committee substitute. I will say that it was worked on by many more people than myself. Brad Vaughn in the Lieutenant Governor's office and the Speaker's staff and council and their folks on that side all have worked together. We believe that this final product is an agreed upon solution from both bodies. And I'll hit just a couple of things because I know you don't have time for more testimony on it today because it's been heard pretty good. There are quite a few sections in this bill, and even though it doesn't really flow perfectly starting from front and going to back, that's what I'm going to do, and I'm just going to hit the highlights. And I'll say to begin with, I think that all of us are aware that almost every single school event shooting has a mental health component to it. These are people that are mentally ill and sick, really sociopathic type personalities most of the time. And one thing we need to do is identify those people and to try to intervene. What we don't want to be doing is just coming in and prosecuting people after the fact. We want to prevent these from happening in the future. And we've noticed several things that are common themes that in many of these shootings around the country that makes us know what we need to do. I'm going to tell you, first of all, 2 things that have been removed from the House version. And I think a lot of people in the audience here today might breathe a sigh of relief when they hear that, because some of the most areas that cause the most angst have been removed. May happen sometime in the future as we have more time to study these type of things. One thing that probably had the most controversy in our subcommittee hearing was what was referred to as the S3 database and the Office of Safe Schools. What we were hoping to do with that was to kind of document and create a record of dangerous behaviors, threats, et cetera, by students. And amazing number of parents, particularly of teenage boys who know how, by definition, they are immature and compulsive and do dumb things, were fearful that their child might end up have a stigma attached to them of having a record that would go with them permanently about some stupid comment, threat, or behavior they had done as a teenager, when in fact they were really not a criminal, never engaged in criminal behavior, and it was just immature behavior. Of course, that's important for us to find these indicators, these warning signs, and so we had that balancing act. Are we going to keep this record somewhere? If so, how are we going to keep it safe? Will it ever terminate? Will you rotate off of it? And it became almost overwhelming for us to sort that out and do it in a responsible manner that protected everybody's due process rights and privacy rights, yet still created some type of database. So that has been removed from this bill, the S3 database. And I think the House is okay with that. That's something they spent a lot of time and energy, and JIMSA now was willing to carry that, but that's going to be backed out of this bill. There were also threat management teams that we were going to place in every school, and that became very complex and very cumbersome, and so those have been removed. And I think that will satisfy a lot of the opposition to this bill. So let me run through what we're doing. And these all work together. They're all different tactics, different approaches where we can make our schools safer on a physical way, and also identify dangerous behavior and mental health problems as early as possible so that we can intervene. School administrators will be wary and aware of that, and we can prevent these type of incidents going forward in the future. And I'm happy that the first part of this is actually a Senate bill. You'll remember that we passed Ricky and Elisa's law that is in the first part of the bill, and this is on page 4. This is pretty much verbatim from the part that passed the Senate. Jason Anavatarte carried the bill, and it was in honor of some of the victims there at Appalachia High School. It does two main things. One, it is requiring us to coordinate local law enforcement responses and with all state levels to any of these events that happens. We want to coordinate, really got multiple local, state law enforcement, first responders, et cetera, and a couple of things to make that easier for them to do. Number one, it requires there to be school mapping data imposed for each school, and this is essentially a way to have a common standard, almost schematic diagram of each school where you know the points of entry, you know where the hallways are, the stairwells are, the library is, the lunchroom, ways in and out, even know where the critical utilities are, and some of these have defibrillator kits or trauma kits or emergency response kits, and to know what's the local surrounding parking areas, fields, roads, outbuildings, and other neighboring properties. So when you are sending law enforcement to respond, they know where they're going, even if they've never been in that school, because they have this schematic computer program that gives them the details of that school. So if somebody calls from 911 and says, we've got a shooter in the West Wing, classroom B, they know exactly where they're going and how to get in and out of that school building and to get students out. So that is one thing, and we're going to have GEMA develop the rules and regulations for the school mapping. So every school will have this done to help assist law enforcement response. Also, in conjunction with that, is we want an emergency sort of, I don't know if panic button's the word or whatever, but we need an emergency response, and we have that. You've heard the clicker some of us have, if you want to, in the Capitol, where you can call for help if there's an emergency, something going on. So we will have the ability to let folks know when something's going on. to notify of that. So those two things came from the Senate bill. One other thing that everybody recognized at Appalachia is many times the problems come from students that have transferred in from another school, and the new administration doesn't know their history. They don't know if they've been a problem child, a disciplinary problem, whether they've got mental health problems, and we want to make sure to expedite the transfer of your educational record from the previous school to the new school. And if you go into a little bit deeper in the bill, you'll see that on page 9. This is part 2 of the bill that starts on page 7, but if you go down to the bottom of page 9, it requires the administration of the school the kid has been at to transfer the education record and any IEP there may be for a student within 5 business days after being notified the kid's coming to the new school. And that's to let them know the record of that child. Now we want, if you go on to page 10, the information that must be included in those records are, number one, have they ever been adjudicated delinquent on the commission of a Class A or Class B felony act? Without having to do the cross references, those are violent crimes. They are significant, serious crimes like aggravated battery, aggravated assault, burglary, breaking and entering, kidnapping, car theft. They're not minor offenses. So if a child has been engaged in serious criminal conduct, or delinquent conduct is what they refer to it as when you're a juvenile, it's the same thing, doing the offenses that would be a felony if you were an adult. That must be kept in the record and reported. Whether they're on a suspension, either short-term or long-term, if they've ever been expelled from the first school, if they're the subject of a pending disciplinary hearing. Sometimes kids leave a school because they're being punished there, or they're being suspended or expelled from that school. If they've had a notice of a criminal action, if they're a chronic disciplinary problem, or if they have a disciplinary and behavioral correction plan, those have to be identified to them. Some of these records require parental consent to release if they're kept by courts, etc. And they're required to get a verbal and written consent from the parents to disclose these records so that they can travel with the student. I think that's going to do a lot to help the new students, new schools know what's happened, what kind of students are coming to them, so they can be alert and aware of potential problems. Now in section 2.2 on 14, this is a great idea that each school system is going to have a qualified student advocacy specialist. Every school system gets one, and we're going to have state grants to fund these, so this is not an unfunded mandate. Any school system with fewer than 18,000 students will have one of these student advocacy specialists paid for by the state. If you've got 18 to 36,000 students, you get 2 of them. And if you're larger than 36,000 students, you'll have at least 3 qualified student advocacy specialists paid for by the state. Now, local school boards can have as many as they want, and some of them might find it necessary to have a much higher number, but that would be at their expense. So what this job is to do, the student advocacy specialist, I'm now rolling into page 15, they are to coordinate the efforts of the local school system to identify and facilitate appropriate interventions for students that either have or at risk of mental health concerns. So we're trying to address the mental health, and these experts will be able to do that. And to coordinate, document, evaluate, and report Tier 1 and Tier 2 behavioral health training programs to train local school systems and teachers how to identify and treat mental health problems. And this person will also attend information and training meetings relating to school safety and student behavioral health. So we're creating a team, so to speak, of experts in identifying, treating, intervening in mental health problems. I think that's going to be a very powerful tool. Moving on to page 16 in section 2.4, we are going to use RISA to have a dispute resolution service here and to kind of help do mediations if there are conflicts, problems, and I can see potential with parents, disclosures, et cetera, schools, how they handle some of these things. So the RISAs are going to get more involved in the actions of the school. Because we're dealing with a lot of records that are protected by federal law, they're personal in nature, when you get into disciplinary records of a student, et cetera, we're going to create a chief privacy officer that's going to consult with the Attorney General's office, but they will promulgate all the regional educational service agencies and the local education agencies guidance and information that involves the current state and federal laws that protect the privacy of student records, and that includes their education records, their health records, and other personally identifiable information. There'll be somebody to help guide us as what is needs to be kept private, and also to let the schools know what student education records and health records can be shared with other schools when you transfer, with Department of Juvenile Justice, with DFACS, Department of Defense, et cetera. So we're going to have, we know when we start dealing with students' records and we're transferring them more freely, we're going to have to comply with these privacy laws. So we're setting up a manner to do that. There are more sections that go in what's included in a student's records. And if you go with section 2.8, starting on page 19, it lists what we want to be in their records when you transfer a student's record and what we keep for the student. Their academic transcript, their attendance records, their student disciplinary records, which would of course include any kind of suspensions or expulsions, notice of any reports of criminal actions that the student might have been involved in, notice of any chronic disciplinary problems, any disciplinary and behavioral correctional plan, and any reports of a prohibited act, and we'll be getting to those reports here later. Whether or not the student's ever been adjudicated delinquent, if there is an IEP under the Disabilities Education Act, and if they've had any psychological evaluations. All of that information will be kept in the student's record. It will be kept confidential, and we will be disclosing that when a kid transfers. That will help the new administrations know what they're dealing with when a kid comes there. If a student is new to our system or to our state, these same type of requirements are placed on the parent. That before they can be enrolled as a prerequisite, they must execute a document that identifies all of those disciplinary problems or criminal actions. So you can tell what we're trying to do. We're trying to make sure that our local administrators on the school where these students attend learn about their history and their educational record before they got there. So you will be ready to intervene if necessary. Finally, moving on to section 2-10 on page 28, we are now for the first time going to require law enforcement officers, we're calling these peace officer reports, to report any official encounter they have with a school-age youth. So if the law enforcement officer in the course of their job has an interaction with somebody that is in school age up to, I think we identified it, Holt, do you remember 6 to 16? Is that the ages? 26th and 16th birthdays. So if a police officer has an encounter, and this can happen off a school property, so the school administration would not necessarily know that the kid was breaking criminal laws somewhere off campus. This requires the police officer to submit a written report of their official encounters to the school officials at the kid's school. So if you're out, you know, shoplifting or getting in fights or doing something worse, and the police officer has an encounter with you and writes up a report, they have to submit that to the school, so the school will be aware of that type of behavior that essentially would have happened off a school property. I think that's going to help us be more knowledgeable about the kids. Moving on to section 2-12, this starts on page 32, but the guts of it, starts on really the next page. We are going to train school personnel with 2 hours of student behavioral health awareness training. And that's going to be approved by DBHDD. So it's going to be professional. We want our teacher to be able to be aware of mental health problems and the signs and symptoms of those in the students. In addition, we're going to give the students training. If you roll on to page 36, each child, this is under section 2-15, is going to be required on an annual basis to have 2 hours of student training. 1 hour is in suicide awareness and prevention training. Suicide's a bigger problem than we recognize, and it's scary if you ever notice most of these school shootings are murder-suicides. Very often they end with the shooter killing themselves. They are mentally disturbed, and it's often very severe depression, bipolar, etc. We want to teach kids suicide prevention and find when they have those type of concerns or worries and how to identify those in other children. And then an hour of youth-based violence prevention training. So we want our children to spend at least an hour each year learning about suicide and suicide prevention, and then also learning about violence prevention training. And in that, what we're going to teach them, if you look on page 37, how to recognize the observable signs and signals of depression, suicide, or self-injury in themselves and in their peers. How to recognize the observable warning signs and signals of a person who may be at risk of harming themselves or others. Teach them the importance of seeking help for themselves and their peers, and the process how to get help if you recognize that you're having symptoms of mental illness or fears of suicide, etc. And the steps that can be taken to report dangerous, violent, threatening, harmful, or potentially harmful behavior. In conjunction with that, on page 38, you'll see we're going to require each local board of education or public school governing body to develop and to operate and make available an anonymous reporting system. And that type of system must be accessible by anybody to anonymously report any dangerous, violent, threatening, harmful, or potentially harmful activity which either occurs on or is threatened to occur on a school property or relates to students or personnel. So what, you hear that, see a problem, tell about the problem, or however the phrase goes. If somebody notices dangerous or threatening behavior, this gives them an anonymous way to report that conduct. It's got to be open 24 hours a day, 7 days a week, at least through a mobile telephone application or some type of crisis center that's staffed by people that are educated about evidence-based counseling and crisis intervention training. And if a report is made anonymously, it should be promptly forwarded to the appropriate school-based team. I like this part that it gives us a conduit, a way to report threatening, dangerous behavior if it's observed. So we've taught the students how to observe it, how to notice it, how to be on the lookout, and then we've given them and parents or anybody else an ability to report it where it can alert school officials to potential dangerous behavior. Section 2-16 on page 40 gives a procedure for reporting excessive absenteeism. You're going to notice an awful lot of these kids that are involved in these violent acts have dropped out of school, or they stopped going to school. And this is if any student does not attend school for a period of 30 consecutive days, and the parent hasn't told the school why. Maybe they were traveling, maybe they were ill, maybe they were deciding to enroll them in another school or a home study. If they've not been withdrawn from the school, or the parents explained why their child's been out for 30 days or more, if they're 16 or older and they haven't had their conference to drop out of school when they're able to, that must be reported to DFACS. Because these children families need to know that they're not going to school when they leave the house in the morning. And DFACS needs to look and see why. So that's new in this bill, is this mandatory reporting for the excessive absenteeism. A couple other highlights. Each school is going to have to create a safety plan. We already have these, but they're going to need to address behavioral health needs of the students and a behavioral threat assessment management plan that provides a multidisciplinary process to identify, assess, and mitigate potential threats to support the safety and well-being of students and school personnel. This is section 2-20, starting on page 47. And sort of rolling back, you also have to have a behavioral threat assessment and management process and a plan that utilizes guidance from GIMSA, who is there for you to help you prepare this threat assessment plan. So we're doing a lot of different things in this bill to prepare a plan to protect safety, to have the mapping, to have the immediate warning signs and identifications. We're trying to educate our students. We're trying to have trained personnel there to identify mental health problems. And I think all of this together will do a lot. There's another part that is common to both Senate Bill 61 and the House Bill 268 that deals with terroristic threats. And basically, we're making certain that these type of threats and crimes are dealt with seriously. And just like there are no guns on campus, you know, there are certain complete no-nos that there's just zero tolerance for. That's the way we want to approach a couple of different things. You know, one is terroristic threats. If you are threatening, and I'm now in the last section, pages 54 to 56, if you're threatening violence to the students or the property of a school, we're not going to put up with that. So if you're making any threats to commit a crime of violence, to release a hazardous substance, to burn or damage property, and you're doing that with the purpose of terrorizing another person on public or private school property, or on a school bus, or at a public or private school-sponsored activity, especially if you have the purpose of causing the evacuation, like a bomb threat, if you're wanting everybody to evacuate a bus, and if you're in reckless disregard of the risk of causing terror or evacuating, that's going to be a felony offense now. Or if you use a weapon or flames or hazardous substances in the commission of these unlawful acts, or to terrorize another person, that will be a felony offense. And that's going to be punished as a misdemeanor for a first time unless there's a threat of suggested death, in which case it would be a felony. Fine of no more than $1,000, in prison for not less than 1 or more than 5 years. I think I've hit the highlights. There may be some parts that I have missed. I'm happy to answer any questions. Representative Persinger is my phone a friend, since it's really his bill. We have other people here that are able to answer things, but you can see this is an extraordinarily comprehensive approach to addressing the known problems we have with school violence, and hopeful with God's help we won't have another Appalachia in this state.
All right, thank you both of y'all for your work, and everyone else in both chambers that got together to get a comprehensive bill that everybody seems to be on board with, so we can get this done the next week. You do have some questions on the committee. Senator Steele.
Thank you, Mr. Chairman. Getting to serve on our subcommittee with Chairman Cowser, I just want to say your description of this bill, your work with Representative Persinger, absolutely amazing. Thank you so much for putting the work in to do this. It's been an honor to work with you on it.
Thank you. I appreciate your service on that subcommittee too. We learned quite a bit, and Representative Persinger has helped educate me behind the scenes as well. Thank you.
Senator Parent.
Thank you so much, Mr. Chairman. Thank you. Chairman Cowsert and Rep. Persinger, I want to direct the question at you, Representative Persinger, but I think you'll maybe also weigh in, Chairman Cowsert, and that is, I've received a lot of emails pleased with the hard work that's gone into this bill. I also received a little nervous about some of the, threats databases and the penalties that could be faced by kids. I know that, am I correct? Some of what was in your version is out and a different version is in. Can you run through that for me specifically again one more time in terms of what is out and what is in?
So the S3 database and the BTAM team specifically were pulled out.
The BTAM, the behavioral threats.
Management teams, yes.
Okay, why were those pulled out?
Those are still voluntary. I mean, those are currently being used in systems currently, and GMA offers training on those right now. So I think it's not mandated in this, but it's still offered through GMA, and systems are using those now.
So it was mandated in what
Correct.
passed the House, and now it's voluntary. Okay, thank you. And then to the other part, the S3 is out.
Correct.
Okay.
It's out totally.
And-
So that was what brought the most consternation from parents. There were some people that feared that their child might be racially profiled. Some thought that they might be stigmatized from having made careless comments, we'll say, or misinterpreted comments that then went into a permanent database and record before they were even charged with a disciplinary offense or charged with a crime. There are things that would be helpful for administrators to be aware of, but you really get into some personal privacy rights and some stigmatism there if you don't really carefully handle that. And because of the pushback, for example, we had lots of testimony is, when would this roll off of somebody's record? Would, if they go 2 or 3 years and never do anything else stupid, should you take it off? Do you wait till they graduate from high school? Well, then you're not warning colleges of it. So do you keep it on there till they're college age? And you could see the quagmire. So we felt like it was best at this time to take that database out completely. You would still have a student record, and I just went over a couple times all that goes in there, but mostly educational record, attendance records, disciplinary problems, and criminal problems that they've had due process on.
Okay, thank you. Just one quick follow-up. This is essentially, I guess, drilling down a little bit more into what you just explained. I'm looking at the Senate research summary, and it says that it has removed the penalties for a terroristic threat to individuals within a school and penalties for parents who aid their children in threatening individuals, but adds language from SB 61, which is Superior Court's exclusive jurisdiction over trials of children, in creating the offense of a terroristic threat to a school and the offense of terroristic act upon a school.
Right. So we added those two offenses as things where juveniles can be treated as adults. That's the sort of the translation when you go to superior courts. I'm looking at my ex-prosecutor here, the minority leader, that gets that if they are terroristic threats for damage or harm to people on school property, that can be treated as an adult.
Yes, and I remember the bill.
Yeah.
So, but wouldn't that particular, going to being tried as an adult be actually harsher penalties than what was in your bill to begin with, Representative Persinger, for terroristic threats?
Can you ask that again?
Well, if your language about that had to do with some penalties for terroristic threats for students who made them and potentially their parents is out, but what's in is being tried as an adult for the offense of terroristic threats or acts. Am I understanding that what is now in is actually a more severe penalty than what was taken out, or am I wrong about that?
No, I think it's true. Things in our bill, it was just increasing that to a felony if you made the terroristic threat, if it was a credible terroristic threat. And I believe the language in 61 is talking about, I think they added terroristic act on line 1279 and attempt to commit murder were the two line items that were added to the list that would already go to Superior Court jurisdiction.
I can chime in a little bit. The current law now, if you're between 13 and 17 years old, so you're really a juvenile, you can be tried in Superior Court as an adult for murder, voluntary manslaughter, rape, aggravated sodomy, aggravated child molestation, aggravated sexual battery, armed robbery if it's committed with the firearm, and aggravated assault if it's done with the firearm, and aggravated battery on a public safety officer. That's current law. We add to that an attempt to commit murder, so it's not murder, or a terroristic act upon a school. And that's where we talked about the terroristic threats, and it describes those where you're basically threatening to shoot up a school or blow up a school or do. You're threatening death or serious injury to a group of individuals who are or are likely to be at a public school bus, a public school bus stop, or a public school event.
Thank you.
Any other questions from the committee? All right, what's the pleasure of the committee? Motion to pass by committee substitute from Senator Steele. Do we have a second? Second from the pro tem. Any discussion? All those in favor of the motion, please raise your hand. It is unanimous. Thank you. Thank you all again for all your work and for the work in the subcommittee.
Thank you, Chairman. Appreciate you, brother. You bet.
All right, Chairman Gunter. Again, we're going to move as quickly as we're able to on these bills. House Bill 582. We are working off a committee substitute, LC 492384S. As you're exiting, please keep your voices down and try to take your conversations outside so we can keep rolling to make sure we can get through these bills. The committee substitute that Chairman Gunter worked on with a lot of folks interested in this bill for the last week or so, and I think based on the sign-up sheet where no one's here to speak in opposition, I think you've gotten everybody on board for a good bill. The floor is yours.
Thank you, Mr. Chairman. Thank you, members of the committee. Yes, we've worked hard on this bill, and we've contacted the district attorneys, had them review the bill.
Hold on one second. If you can please take your conversations outside, including our committee. All right, thank you.
Sure. I think we've identified the people that would be most interested in this and reviewed with them what we have in this bill. I don't know if you want to go line by line on this, but quickly, the evidence of that a defendant was subjected to family violence or dating violence or child abuse can be submitted to the court for a defense of justification, also for mitigation after they've been sentenced, or before they're sentenced, excuse me. And then those, and I think this is the main part of the bill, or the one that gets the most attention, is for people that have been convicted and sent to prison, and this evidence was never given to the court because the defendant either was pro se and pled guilty and didn't know that they had evidence like this that could help them. So this allows them to come back in and present the evidence to the court. This is not a get out of jail free card. This is a reduction in the sentence, and that's outlined in the bill as well. So that's really the main part of the bill. Is just it's to present this evidence and have the courts deal with it.
And there was some concern from prosecutors, and you were able to work with them to get PAC to a place where They give us either neutral on the bill, which is in a half thumbs up, neutral and thumbs up, neutral on the bill. I appreciate your work with them as well. Ms. Dillard, do you want to have, you are Ms. Dillard, right? Gotcha.
I'm Ellen Williams.
Okay,
Also,
Ellen.
I work with Ms. Dillard at
Okay,
the Georgia
that's-
Coalition Against Domestic Violence. My name's Ellie Williams. I'm the legal director of the Justice for Incarcerated Survivors program at the Georgia Coalition Against Domestic Violence. We provide post-conviction representation in criminal matters to survivors of domestic violence whose convictions are closely related to the abuse. Started as a small pilot project, largely with the support of Crystal Moon with the Board of Pardon and Paroles, folks from CJCC, a lot of people across the state. We've grown into a nicely built out direct representation program. But we're very grateful to Chairman Gunter for all the fantastic work he has done and championed this bill and this issue. And we're really grateful to you guys for hearing us today. And I'm just happy to help answer any questions that anybody
All
may
right.
have.
Do you have a question from Leader Hatchett?
Thank you, Mr. Chairman. Just so I understand what we're doing here, and I support this, but for the committee and those that may be listening, this is an attempt to give someone a second chance that was subjected to violence, that may have been, for lack of a better word, held captive by their abuser, and basically had to make a decision between continuing to go along with what their abuser was telling them to do. I know a lot of times it's check fraud in domestic violence situations, or face harsher consequences at home. And so a lot of times they decide to commit a crime that they wouldn't have otherwise committed had they not been in the situation they were in. And now, if this were to pass, those, and I think the majority of them are women who have been subjected to that and are now serving, will have a second chance to show that the reason they committed the crime that they committed was because they were in duress and didn't have a voice.
And there is a limitation in how much they can come back to the court. They can do it initially, and if any new evidence comes up, they can use that as well.
Well, I just want to say I thank the chairman for bringing this, and I support this bill.
Any other questions or comments from the committee? There's a few other folks signed up to speak in favor of the bill. Does anybody else want to be heard? They wave. What's the pleasure of the committee? Motion to pass from Leader Hatchett. As I expected, a second from Chairman Calzert. All those in favor of the motion, please raise your hand. It is by committee substitute. It's unanimous. Thanks for your work. This stuff looks fast up here for those that are watching, but I know how hard y'all work to get this bill in the place it is. So thank you for your work on this great bill.
Thank you so much, Chairman.
And
Strickland.
who is carrying the bill in the Senate? Oh, he was already doing his speech for the floor. Good job. It's a great bill. Thank y'all. All right, we are going to House Bill 618. We have a committee substitute, Representative Campbell, come on up. We've heard this bill a week or so ago. And since that time, we had individuals that came to us from the state bar and also realtors that were involved that had a lot of comments. And my understanding is that the author of the bill was able to get with the interested parties and brought us a substitute. So I would like for you to focus on the changes to the bill that were made from the last hearing. So the floor is yours.
Okay, thank you, Mr. Chairman and the committee. What this bill is based off of what we presented to y'all last week, and the flood disclosure earlier that needed some fixing, and some cleanup language and some transparency, and we've done that. And that I'm glad you asked that. That's exactly what we would like to do. I've got two people here with me that did most of that work, and it's their field that they're in. And what I'd like to do is introduce Ms. Brody right now, and let her give y'all her credentials, why she knows all this, and also all the changes that you were involved with and why we did it and all that. And we've got Mr. Jeff Ledford here with us that can also do the same if there's a need for it.
I believe Mr. Ledford, Section 2 was what was new from the realtors, and we'll address that in a second. And Ms. Brody, do you want to go over quickly the changes to the bill as well, please?
Absolutely. Thank you, Mr. Chairman, and members of the committee. My name's Ann Brody, and on behalf of American Flood Coalition Action, I want to thank you all for the opportunity to represent this bill today. And some context on who we are and why on earth I'm here. American Flood Coalition Action is the 501c4 arm of the American Flood Coalition. We are a nonpartisan, nonprofit coalition comprising, I learned today, more than 470 elected officials. My notes here say 450, we're growing. And those are local leaders, municipalities, civic and military groups, businesses from across the country that are working together to advance flooding solutions. And that is the lens that we are looking at this through, and why this is a bill that we are strongly supporting here in Georgia. Some of our coalition members include Chatham and Camden County. And I'm going to be very brief. I know we're short on time. Just talk very quickly about why this matters, and then I'm going to run through the big changes. A recent report, which I believe are in your packets, found that Georgia ranks third in the nation for highest flood-related costs, approximately $142,000 over the life of a 30-year mortgage. And as you all likely already know, flooding is not covered by your standard homeowner's insurance policy. That same report found that Brunswick had an average annual loss of $38,000 from flooding, while Atlanta, Sandy Springs, and Alpharetta, all notably non-coastal communities, had the largest number of flood-damaged homes. And states with strong flood risk disclosure requirements, like the one you have before you, generally have a higher percentage of residents with flood insurance. And that matters because flood disclosure is a no-cost policy that gives buyers crucial information so that they can make informed decisions and aren't left vulnerable to potentially devastating loss. On the flip side of that, it can also save homeowners money if they know with certainty that their home is not vulnerable to flooding. Then they don't need that insurance policy, and that can save them tens of thousands of dollars over the cost of a mortgage. And so if a homeowner's property is flooded and they do not have insurance, they have two options. They can either pay out of pocket, which is tens of thousands of dollars. 2 inches of flooding causes approximately $25,000 in damage. I don't know about y'all, but I don't have that kind of cash on hand to fix my home. The other option is to seek assistance from FEMA. And individual
Ms. Brody,
assistance.
I want to cut you off, but we're going to lose a quorum. You tell us the differences in the bill
Yes, sir.
from last time versus
Do you want
now.
me to go line by line or big picture?
Line by line. There's only a few changes I know from the original version. If you could quickly do that before
Yes,
we lose a quorum.
tightened up the definition of flooding to remove the phrase other severe storm or deluge and add instead, or the unusual and rapid accumulation of standing water resulting from a storm. We also added on section B, prior to any arm's length transaction of any 1 to 4 family residential real property. So that clarifies that it's residential homes that we're discussing here. It also specifies that any disclosed flood damage has to have happened during the owner's ownership. They are not required to disclose events and damage that occurred before they owned the home. We removed parts 6 and 7 regarding floodplains, added that on section C, page 2, shall be based on seller's knowledge of a flood impacting such property during such seller's ownership. So really hitting home that it only applies to the seller's knowledge during their ownership of the property. Moving on to page 3, we removed the adverse material fact section as well as the public and private remedies section, and instead the language reads, any willful omission to any disclosure requirement provided shall be considered an unlawful act. And then crucially, part E, nothing in this code shall be construed as requiring a seller or any real estate broker or advisor representing or working with the seller, landlord, buyer, or tenant to undertake any independent investigation or inquiry into any subject matter requiring disclosure. So if they don't have actual knowledge, they are not required to do any additional research.
All right, thank you, Ms. Brody. Any questions for her about those changes to the bill from the committee? All right, thank you. Mr. Ledford, I know we added Section 2, which was another bill I think you previously worked on that deals with liens that are put on properties that are not in good faith. You want to tell us a little bit about that?
Absolutely, thank you. This portion is actually almost the entirety of the whole other bill. It was House Bill 676. We've seen a recent rise. I think for the past 3 years, I've been coming to you with predatory practices, fraudulent issues. This is one where there are bogus liens being filed on properties to try to extract or extort funds from folks before a closing. Essentially, that's addressing this. It's not something that's really legal right now, but this is a punitive action to help prevent people from using that as a business model, which is what we've been seeing a rise in.
Mr. Walker, one question I have on the line 56, when it says in addition to any attorney's fees or court costs, my understanding is normally when you have court attorney's fees provisions, there's some limitation to the finding of reasonableness or at the discretion of the court. Do we need any additional language to make that match other provisions?
Thank you, Mr. Chairman. Yes, in line 56, it would be appropriate to insert reasonable between any and attorney's fees.
And do we need to say at the discretion of the court, or will that be implied?
I don't think that would be necessary. Yes.
Okay. All right. You good with that change?
That's perfect.
Any questions from the committee? What's the pleasure of the committee? Motion to pass by committee substitute from Leader Jones, a second. Senator Parent, does someone want to offer the amendment for adding the word reasonable between any and attorney's fees? Is that right, Mr. Walker?
I would actually recommend replacing any with reasonable.
Replacing any with reasonable is offered by Senator Parent, seconded by Leader Jones. All those in favor, please say aye. Aye. It is unanimous. Back to the motion to pass by committee substitute as amended. All those in favor, raise your hand. It is unanimous. Chair Watts, we're going to do ethics the same way today? Good. All right, in a couple hours. All right, who's carried the bill in the Senate?
Ben Watson.
Ben Watson. All right, good deal. Thank you all for your work. Thank you.
Thank you.
Thank you, Representative. All right, we got to keep a quorum, but this is a very important bill. I know a few folks want to be heard on it, so we're going to move to House Bill 36. Is Chairman Leverett, come on up. So I'm going to try to move us as quickly as we can, but again, important issue, but let's not over talk it. The floor is yours.
Thank you, Mr. Chairman. This is a bill that the committee has seen twice before. It tries to respond to a problem we're having in the probate courts because they're having a hard time getting the professionals who can provide an evaluation in a guardianship or a conservatorship proceeding. They're having a hard time getting the ones who are currently statutorily qualified to actually provide the evaluation. And that's important, really, regardless of what the outcome of the case is, because it's needed to help the case move forward. It's not the only piece of evidence that the court considers. It's not a guarantee that there'll be a finding that a guardianship or conservatorship is needed, but it's a piece of evidence the court looks at, and the court has to have that in order to determine whether the case proceeds to a hearing or not. And so it's causing the cases to languish, the fact that they can't get the evaluations. So what we're doing in this bill is expanding the list of professionals who can provide the evaluation. And again, this is not a mental health diagnosis. It's not even really an assessment of capacity necessarily. It's just an evaluation as to whether under the circumstances the proposed ward, the person for whom we're trying to obtain the guardianship or conservatorship, meets the relevant legal standard, which is basically lacking sufficient capacity to make or communicate significant responsible decisions concerning either their personal health and safety if it's a guardianship, or the management of their property if it is a conservatorship. So this bill, we've run it the last 2 or 3 years, and we've just not been able to get on the Senate floor. It's needed in the probate courts. These are extremely difficult, emotionally wrenching cases, and these evaluations are needed just to determine if the case gets dismissed or if it continues. And I will say, I think Ms. Dinsmore and Mr. Miller are here. They can state their objections and concerns better than I can. I've made some changes to try to address those concerns, And I think while they appreciate them, they still have concerns that they're going to share with you, and they would like further revisions, which I feel I can't make because it will kind of frustrate the whole purpose of the bill. So there are changes in this sub, which I'm glad to go through. I've highlighted them if you'd like me to review them, but I will say they basically are trying to address two issues. One, making sure that somebody can still challenge an evaluation even if it's by someone who's statutorily qualified. They can still challenge the sufficiency of it, the experience of the evaluator, or I think the concern that my friends here have is the ability of some of these professions to evaluate someone who's got a developmental disability. Secondly, I try to make clear in the bill by amending the conservatorship and guardianship statute to say that the presence of a developmental disability alone is not the basis for granting a petition to have a guardianship or conservatorship established.
One of the concerns I've heard is whether a marriage and family therapist will be qualified to make these determinations. What, in your opinion, makes them qualified, make them consistent with the other people that are listed in code?
Well, I think we have some witnesses who, if we can get to them, Mr. Chairman, I know time is limited, and I appreciate you placing this bill on today, is they are qualified. They have training on mental health and on mental state. And right now, we allow physicians, psychologists, and licensed clinical social workers to do the evaluation. I respect licensed clinical social workers, but I would think some of the professions we're adding have as much, if not more, training in this area that would be relevant to an evaluation than social workers would.
Okay. Any questions for the author? There's folks that want to be heard on the bill, and you'll get a chance to come back up at the end.
Thank you.
All right, let's start with our testimony. Thank you. Judge Kelly Wonk, come on up. Does Judge Poland want to come with you? Is that okay? Perfect. Y'all are good. Not going to ask which one's the dog or the pony. Yes. How are y'all?
We are well. Thank you, Chairman. Thank you, committee. This is actually the result of a conversation that I had with Representative Scoggins years ago. I was on a study committee back in 1999, and this was a problem. It has been a problem since then. I am not at all. I grew up providing respite care to disabled individuals. I was doing catheters and percussion therapy and doing food for people who could not swallow at 15. I worked with Georgia Advocacy Office. I do not take these decisions lightly, and I do not take the concerns lightly. The thing that I think is that's being lost in this, and I'm not here to advocate for any professional group, other than judges and those who need this assistance. What is happening in reality is a family member is coming in to file a guardianship, and there is no qualified individual willing to serve in that jurisdiction. So the court is having to ask the petitioners to identify a person to conduct the independent evaluation. So the independent evaluation is being done at the selection and direction of the filing party, the adverse party to the proposed ward. It fully defeats the purpose and intention of that independent evaluation. Our hope is to improve the process by having a qualified individual available. We have, in the third largest county, we just added our 4th evaluator. For 800,000 people, we have 4 evaluators. In counties in Georgia, there is not a qualified individual who even lives in the county. I want to be sensitive to time. I'm willing to take any questions. This is a piece of evidence. This is not a decisive. If it was their decision, they wouldn't have to come to court. We just let the professionals make that determination. And by the time we get to a hearing, if it is not consented to as a report, it can't even be considered the evaluation report at the hearing. It is a probable cause determination threshold to get to a hearing where the evidence is presented and considered. with that?
Nothing to add other than I just want to stress too, we have tight deadlines in some of these. So not only are we trying to find a qualified individual to do that evaluation, but on emergencies, we're trying to find that person to do that evaluation within 3 days. And that's all statutorily required. We have no option to just push it out farther because it's hard and we don't want to. So, so I just want to stress the difficult position that it puts judges in to meet the statutory requirements.
And they're always filed on the Friday before in a holiday. So when we have 72 hours, we have 72 hours. So that's our dog and pony show.
Any questions from the committee for the judges? And I do think it's important, most of us, even that are lawyers, don't spend a lot of time with these types of cases necessarily, but important as you hit a little bit on the process, and that these are individuals that are doing evaluations, but they still obviously come before you for you to make the final decision. We're not giving this decision these individuals. Is that true?
That is very true.
Okay.
Yes, thank you.
Any questions for the committee? All right, thank you.
Thank you.
Tom Black?
Yes, sir.
Come on up.
Thank you.
Thank you. And you're with, I'll let you tell us who you're with. I can't read the handwriting, but.
Thank you, Mr. Chair and committee members. Appreciate your time and patience today. I am a licensed professional counselor. I'm with the Licensed Professional Counselor Association. I've been in regulation. I've been in licensed professional counselor. I'm sorry, I'm trying to talk fast so you
You're
get out
fine.
of here. 30 years I've been licensed. I do primarily forensic work. I have 50 therapists who work under me or with me in Southeast Georgia from Augusta down. I get calls from judges often. Can you do these evaluations? In different states that I'm licensed in, I do have that ability. I do have the education, training, and experience, and my staff have the education, training, and experience. I work with MFTs, and I've been on the licensure board since 2012 with an 18-month or so break during COVID to take care of family and things like that. And I do review the education, training, and experience of clinical social workers and MFTs and LPCs on a daily basis, hundreds of them every month. And the education is consistent. It's not identical, but it's consistent. We're all clinical. We're all independently licensed and independently practiced. We bill health insurance. We are health providers. So I just wanted to add that out there. You are going to hear, and I'm certainly sympathetic to the concerns. It's a concern I have as a regulator, that people are making decisions or making recommendations that are inappropriate or inconsistent with our ethics. I'd also like to say that within our ethics, which is part of our law, our Practice Act, we are not allowed to do anything that we don't have the education, training, and experience to do. But I have no objection, and I don't think any of our professional groups for MFTs or counselors have any objections to adding the change to the bill that was mentioned earlier. So with that, I'll gladly take any questions. Just in time for
Any
dinner.
question? I know we're having dinner brought in. Yeah, I thought we were stopping at 6:50. You get us food, we'll just take our time.
Appreciate it.
It'll take as much time as you need. Come on up and get a snack. I'm sure it's cold. Any questions for doctors? Dr. Black,
Dr.
right?
Black, yes, sir.
Any questions for Dr. Black? Do you have a question from Chairman Watson?
I think ethics is meeting next in here, Mr. Chairman, so
Oh, okay.
for supper.
Okay, good. That's not a good sign then, because I thought I had an end to my day coming. Thank you, Dr. Black. No
Yes, sir.
questions this time.
Thank you very much.
Miss Elizabeth Appling, come on up. Good evening.
Good evening, Mr. Chairman, members of the committee. My name is Elizabeth Apley, and I'm here on behalf of the Georgia Association for Marriage and Family Therapy. Licensed marriage and family therapists are included in the mental health professionals, included in the addition to this legislation. These are the core mental health professionals, LMFTs, LCSWs, who are already included in this legislation, licensed professional counselors along with psychologists, psychiatrists, and nurse practitioners in mental health are part of the 6 core mental health professionals defined by the federal government. We have been licensed in Georgia for over 25 years. We are regulated by the same composite board with the same master's or PhD level of education, the same year of practicum experience during that master's education, as well as 2 years of clinical direct supervision following the master's education. All of those are comparable for the 3 professions, and as has already been testified, the social workers have been included as authorized evaluators under the statute for decades. All three professionals have the same authority to issue 1013s, the emergency mental health evaluations, to be reimbursed by Medicare and Medicaid and by private insurance. And I also want to underscore for the benefit of the committee, if you look at pages 4 and 5 of the bill, you can see what the nature of the evaluation is. As the author and Judge Woke emphasized, this is not a diagnosis, although MFTs, LCSWs, and LPCs are all authorized to evaluate. The purpose of the evaluation is to interview the ward, the proposed ward, to observe the ward and assess their functional abilities, review their records, assess cultural factors and language barriers, and other relevant factors. And when they're filing their report, you can see on page 5, they describe the evaluation, the people who are interviewed, the mental and physical state and condition, observe facts, and describe the overall social condition of the proposed ward, including support, care, education, and well-being. Describe the needs of the proposed ward and their foreseeable duration. So you can see this is primarily a factual gathering function. And we appreciate the interest of the probate court in expanding the licensed professional evaluators competent to do this work. Happy
Thank
to
you.
answer any questions.
Thank you, Ms. Sapling. Any questions from the committee? All right. Thank you. All right, we have 4 individuals here in opposition to the bill. Are y'all, Charlie Miller and Charlotte Dinsmore, do y'all want to come as a pair? All right, come on up. Good evening.
Hello, hello.
Good evening.
I'll let Charlie kick us off if you want to. We're both here from the Georgia Council on Developmental Disabilities. Good to see you all. Thanks for having us.
Good evening, y'all. Sorry, I got screwed up, y'all. So good evening. Like Charlotte said, we're with the Georgia Council on Developmental Disabilities. I am the Legislative Advocacy Director here at the Georgia Council on Developmental Disabilities. I first want to start off to say that our whole job, our whole council, is to make sure the voice of the disability community is heard. And that's exactly what I am so happy to be doing today. And I appreciate the chairman and everyone here today to listen. I'm here to speak about House Bill 36. I have already heard I've already had conversations with a lot of y'all about this bill. I appreciate the opportunity to bring my perspective, and I want to be clear. We're not here to debate the merits of guardianship itself. We may have to buy dinner if we were going to go that deep. I want to stress. Instead, I want to stress that if we're going to be expanding guardianship in any way, sort of form in Georgia, we must do so carefully and mindfully. I appreciate the author of the bill for his willingness to make the changes, but after reviewing the current version, there remains one significant concern: the expansion of who can evaluate individuals for permanent guardianship. House Bill 36 expands the guardianship process by adding 5 new professions to the list of who can evaluate individuals for permanent guardianship, a decision that restricts fundamental rights for people with disabilities. This is everything from voting to independent living to even healthcare rights. The first 3 listed professions, physician assistants, nurse practitioners, and clinical specialists, do not raise any red flags with us. And I want to say we understand backlogs. We totally understand that issue, because in the disability community, we have a backlog of 8,000 people with disabilities seeking services in Georgia. So we understand the need to make sure backlogs get taken care of. I do want to say the next two licensed marriage and family therapists, LMFTs, and the licensed professional counselors, LPCs, are concerning to the disability community. While these do play a vital role in mental health care and evaluating someone for guardianship requires a long-term clinical assessment that falls outside of the therapist's typical scope of practice. It is crucial to recognize the difference between the role of an LMFT and that one of a medically trained professional in this process. LMFTs and LPCs specialize in therapeutic interventions, counseling, and mental health treatment that is definitely needed in Georgia's communities. Medically trained professionals, like others on this list, are trained to assess long-term cognitive and functional impairments. Determining whether someone requires permanent guardianship involves complex medical and neuropsychological factors that extend beyond the expertise of LMFTs and LPCs. House Bill 36 risks placing significant legal authority in the hands of professionals that may not. Who do not have the necessary clinical background to make such life-altering decisions. And I promise to be quick. I apologize. If the justification for guardianship is that some individuals with disabilities are so significantly impaired that they require guardianship, then those cases would typically not be handled in a counseling setting. Their families may seek counseling, but at that stage, a medical doctor would be deciding the individual's ability to care for themselves. This means that even the required 2,000 hours of practice, it is still highly unlikely that a licensed LMFTs and LPCs have had an experience working with proposed wards. Permanent guardianship should be reserved for professionals with specialized training in long-term capacity assessments. The bill sponsor recognizes this fact and has added safeguards, which I really appreciate him doing and working with us on that piece. That would protect proposed wards by allowing them to challenge the qualifications of their evaluator during their guardianship case. However, why not addressing the concerns about qualifications now? We already have LMFTs and LPCs are not qualified to do this work. Why would we further slow down the probate court? Also, backlogging by arguing the qualifications of LMFTs and LPCs. In each individual case, when we determining their scope of work is better suited for therapeutic settings. I urge you to please consider carefully ensuring that any changes to guardianships are made thoughtfully and cautiously, and a strong commitment to protecting the rights of individuals with disabilities. In closing, we urge you to strike LMFTs and LPCs from the list of professions who evaluate the proposed wards for guardianship. Thank you.
If I may just echo a couple of points that Charlie made, I think he covered pretty much everything. But I just want to add, I know we're kind of rushing this into the last 10 minutes of a very long day and a very long session. But I want to reiterate that guardianship is an extreme legal measure. This completely strips someone of their fundamental human rights. So to rush this decision this afternoon could have lasting consequences for Georgians with intellectual and developmental disabilities. So please think about that as you consider your vote this afternoon. This bill really is a reckless expansion of government power by expanding the folks that could do these evaluations to people who specialize, yes, in mental health care, which is a very important profession, but not in intellectual and developmental disabilities. We heard again and again that they have incredible experience. We know that marriage and family therapists complete over 2,000 hours of clinical work, but those 2,000 hours are required to happen in a medical and family therapy setting, a marriage and family therapy setting. And that is not frequently places where people with intellectual and developmental disabilities are. So very infrequently are these marriage and family therapists around people with IDD. We're very concerned about their capacity to evaluate someone for guardianship. Again, we accept the inclusion of the first 3 professions on the list. We think that that makes sense. They are medically qualified individuals, but these last 2 groups, while they have great lobbying force behind them, are not qualified to be doing this work, and we would really appreciate your consideration to strike them from the list.
You do have a question from Senator Parent.
Yes. Thank you, Mr. Chairman. Thank you so much, both of you. I firmly agree, of course, that we need to be extremely cautious in making these changes. I did hear the judges say that, the interest is really in not having these backlogs where families are kind of begging, to get this done, and there aren't the professionals available. So I take them at their word that there's a problem there in terms of just the number of people who can do the evaluation. I understand what you are saying about marriage and family therapists, because that struck me as odd as well. But then I noticed that licensed clinical social workers are already have that authority. Can you just speak to why you would view the new addition of the 2 that you mentioned? I think it was marriage and family therapists. Was it also professional counselors that you're worried about? Okay. Yeah. Explain to me why, when we already allow social workers, that those those 2 categories of professionals set off such alarm bells.
Sure. Yeah. I don't want to speak too much out of turn, because Charlie and I's jobs are actually governed by a council of people that are at least 60% folks with disabilities, and so they tell us what to do. So I only want to speak in turn of what they've spoken to, which were the proposed additions. But I will say, in general, as a council, we are concerned about how extreme guardianship can be, and I think had social workers been included on this list of proposed changes, that would have raised a flag for us as well. They were just already in the statute, so it's not something that we ran past our council in terms of flags to raise.
Thank you. That's helpful. Yes, guardianship is certainly extreme. I guess what I'm struggling with a little bit is that that's sort of not the question in front of us right now. Exactly. Although I understand that the way you're approaching it, it is related. I guess I'm struggling with, since we have it in the law, right? And that's kind of not really the fundamental debate today. So I appreciate the input on how you're thinking about it and how the council is thinking about it.
Yeah, to respond to that piece, I think our concern is making sure, because guardianship is a thing, and for some folks in the disability community, it is a great option for their family situation. Our concern is making sure that the right individuals are doing those assessments, because they have such extreme consequences for the individual who might be a proposed ward.
Thank you.
Thank you.
Other questions from the committee? Thank you.
Yeah.
Thank you both.
So much.
Thank y'all very much.
All right, next we have Douglas Franks. And is it Rocky Harbin? Are y'all coming? Becky. We didn't look like Rocky, but it looked like it says Rocky on here. Come on up. Y'all want to come on up? If you want to come together. Y'all will close out our witnesses, and we'll let the author of the bill close it out too. Thank you.
Thank you. It's a pleasure to be here today. Get a little closer to this mic. To the chairman and all the other members here of the Senate committee. This is HB 36, and it's reference to guardianship. My name is Doug Franks. I mentioned that earlier. I know a lot about guardianship. My mom was in a guardianship, and she made national and international news, and she also made news here on Channel 2 and New Orleans and all around the country. So I know a lot about guardianship, and I know a lot about people that evaluate people, and they get paid. How do they get paid? Does it matter? They get paid. It's a moneymaker. I have the video of the 3 people that interviewed my mom. No one has that. How come these people aren't recorded when they interview the people that are going to go into the guardianships? Wouldn't you guys like to see what was going on when your mom, your dad, or your friend is put into a guardianship? Well, we have a professional. They're not going to lie. They're going to be honest. They're not going to make extra money and get paid. Again, all that sounds crazy, but man, freeernestine.com is my mom's website. I got her free. After 4 years and $2 million, I got Ernestine free because they didn't know who they were messing with, Ernestine's son, Doug Franks. And talk about a Georgia Bulldog. I am a Bulldog big time, although I'm an Auburn fan. So anyway, with all that said, I would like to furnish you guys with the video of these 3 people. A social worker that was a racist, wanted to know why my mom was going to vote for Obama, not to vote for him. The other person spelled my name. My name's Doug, D-O-U-G. She spelled it D-U-G, a nurse. And then the last person had a heavy Indian accent talking to a 92-year-old woman. She couldn't understand him. And if you watch the tape and if you listen to what they say and find that my mom is totally incapacitated, it's like, you got to be kidding me. How come we can't see this evidence? To depend on someone just to be holier now and just they're not going to lie is a mistake, is a big mistake. So when you bring additional people in to all of this, we can have a real problem because they're not qualified. And the question is, can they be paid off? And if just one person could be paid off, it's too many. But there'll be more. This bill, it expands the options of the misguided Georgia Department of Home Services employees, hospitals, long-term care facilities to mitigate risk via petitioning a patient for guardianship. If there is malpractice risk, hey, let's just put them in a guardianship. Let's petition a guardianship. If there's a receivable risk, let's just petition them to put them in a guardianship. If there's demanding unreasonable services, fees, let's just petition and put them in a guardianship. Again, the fear is, how can this be misused? All this happened in the state of Florida, but guess what? The bank that said Ms. Franks needs to be in a guardianship, even though the trust said the design of the trust is so that it will never go into a guardianship proceedings. Okay, that's the first article. The bank is a bank called, you probably never heard of it, Synovus. Roger Brown with Synovus. He's the one that testified and said, Ms. Franks needs to be in a guardianship. Wow, the first article of the trust says no. So, trust people, I don't know, I don't think so. And guardianship, you suffer a civil death, and that's it. And again, I'm a lottery winner. I didn't win the money, I won my mom. And 45 days, I got to have my mom free. And she was free, and she died in my arms. And I got to tell her, I love her, and everything's going to be okay. All I can say is this is a big deal. And this whole thing about guardianship, just look at the neighbors in Florida, how horrible it is. And what happened in 2012 to my mom, same thing can happen today in Florida. Don't let Georgia make the same mistake. Learn from Florida. Don't do what they did. Do just the opposite. And again, that's basically what I have to say. Again, I represent a CEAR, C-E-A-R. It's a 501c3. Rick Black is one of the leaders, but there's many different groups that are involved in guardianship and trying to stop it and have the advanced directives being taken or the ability to help people make their own determinations. So if there's any questions, I'll be more than happy to answer them.
One thing I wanted to point out, I guess a question for you, looking at one of the things in the substitute is, I don't know if it was the original bill, I don't believe it was, Chairman Leverett, but the ability to now in code challenge the sufficiency and weight of the results and conclusions from the evaluation. Is that something that you do think helps improve our current process for guardianships?
So it takes a lawyer to do that, right?
No, I mean, the law says anybody can challenge it. So
Right.
I'm just saying the current law doesn't have that. I was just asking if you thought that was at least an
So
improvement.
it's important to be able to challenge, it's important to be able to challenge it. But if you don't have the legal ease, you get chewed up and spit out. You don't have a chance in court.
Okay.
And again, I've experienced this firsthand and walked in and walked out, thought, what happened? What happened?
Did you have more you want to add? Yes, ma'am.
Thank you.
Senators, thank you for your time. I am here to express my strong opposition to HB 36, which has already passed the Georgia House and is now before you, Senators. The bill represents a serious threat to patient rights, due process, and the integrity of Georgia's guardianship system. If it's passed, it would open the door to more financial abuse, conflicts of interest, and unnecessary guardianships that strip an individual of all their rights. Unless this happens to you, you have no idea of the seriousness implications of being put into a guardianship. One of the most concerning provisions in HB 36 is its further expansion of who can initiate that guardianship. These individuals do not have the legal or the medical expertise in determining incapacity and would be financially incentivized under OCGA 2993 to push guardianship at the very expense of the individuals that they're here to help. Now, Senators, what I want you to pay attention to is OCGA 2993. The definition of that, where you do not see anywhere in this bill, is, and it's located on 497, line 497 of the original bill, is it is for abuse and neglect of the individual. And I want to tell you a story, and I'll be very quick on a very good example of what happens with 2993. My husband and I were married for 30 years. We were high school sweethearts. I was down in a hospital in Henry County, Georgia, where a nurse in a hospital, under the license of the state of Georgia, she had a criminal record that included a past felony, a current felony of assault with a deadly weapon. She had lost her license in 3 different states, Michigan, California, and Tennessee, and she made up a story on me that I was trying to assault my husband. I was arrested. I was never indicted. No charges were ever taken. I had to hire a private detective to find out why a nurse would make up such a story on me. I would find out later it was to mitigate a lawsuit. So 2993 was used in a writ of habeas corpus in Henry County, Georgia, to take me in there before a judge with no evidence, much less clear and convincing evidence, that put my husband in a guardianship. My husband was taken in this guardianship, and I never saw him again. He died without me, without his mother, without his family. It's very important for you to understand that when you are put into a guardianship, that guardian gets to say whether or not you ever see that loved family member again. So when my husband died, I ordered an immediate autopsy because Adult Protective Services of Georgia was over the care of my husband. So immediately I would find out that he was abused and neglected. He died of wounds and of sepsis. The autopsy was so hard to look at, I couldn't even show it to the court. It was just devastating to know how my husband died. My finances are still in Clayton County Court. I pro se, every one of those filings are mine. I had to represent myself because I cannot get an attorney to take over such a controversial case. So My point is that there is a very important hidden bill in here, and that is, statute, and that is OCGA 2993, and that is abuse and neglect that will give any of these hospital workers the right to say, oh, she left her person in the wheelchair, or she walked out to her car and came back with something and poisoned her husband. 5 wives were taken at the same time that their husbands were taken at the same time as mine. So this is not just an isolated or unusual incident. There's the case down in Florida, Adventist versus DeStefano. That's a $1 billion lawsuit where Mr. DeStefano was accused of assaulting his mother. There's the Take Care of Maya case, what made your news in Georgia and national news, where a mother committed suicide because a hospital took the daughter. I'm going to end this by saying, I had a lawyer tell me when it came to the estate of my husband, he said, Ms. Harbor, just basically take this because your government allows this. And I fired him for telling me that. Senators, you're our government. You have the right to say no to this bill. This is an egregious bill. I want to say one more thing on this. I urge every one of you that's vote on this bill to stand for the U.S. Constitution, patient rights, due process, and integrity of a system that has miserably failed Georgia's most vulnerable citizens. There's the Constitution, which is Article 1, Section 3, and it says if HB 36 enables hospitals and attorneys working with the hospitals to file abuse claims under OCGA 2993 that leads to financial penalties and estate seizures and guardianships without fair adjudication, this could be considered a violation of property rights. So you have constitutional rights, property rights. You also have patient rights in hospitals that are going to be voided. This is a very serious bill, and I urge you to seriously think about it before you say yes. It is no excuse. I'm going to say one more thing. It is no excuse that there is a line of people waiting to evaluate someone. First of all, I had a POA, an advanced medical directive. There was absolutely no reason at all to put my husband under a guardianship, none at all. Most of these guardianships that are being formed, they don't need to be formed. So you don't even need evaluators. So I thank you for your time.
Thank you. Quickly, the 29.9-3, the only reference I see to that is in the existing code in line 702. Is there another place that you're talking about that being put in the bill?
If you read, in other words, when you're put in a guardianship, there's a lot of people that benefit from your estate. So you've got your GALs, you've got your attorney for me, the attorney for my husband, the conservator. They all going to get like under 29, 29.93 up to $25,000. Meaning now there's an incentive, just like with COVID, how we saw the incentive in the hospital to get, for the ventilators. We've all seen that, whether you agree with it or not. That's now the incentive. So you're going to give these hospital workers the incentive to bring forth a guardianship to these probate courts. And I'm telling you that once you're taken in for a guardianship, the chances of you getting out are nil to none. So what I'm saying is 29.93 is for abuse. It is for abuse and neglect or like financial exploitation. So what they don't mention in here is at the very bottom on line 497, and I just asked one of the senators the House representative that is supporting this bill, and he didn't even know what 29.93 was. So when I pointed it out, line 497, it says very specifically they will be paid from the fees of OCGA 2993. Well, that'll be just like right now where the county taxpayers in Clayton County paid the attorneys under 2993 under the abuse and neglect, and there was no abuse and neglect. So that right there is a problem.
All right. I'm just not seeing that in the bill.
Well, if you go to line 497 at the original bill, and I just
Okay.
showed it to Senator Leverson, it clearly says there that they would be paid.
But that's not in, it's not in this bill.
It's
The
on
lesson.
702, Mr. Chairman.
Is it, okay, that's, okay.
Cross-referencing existing.
Existing codes. We didn't change that with this bill, but your argument, I guess, is by expanding those who could do this, they could then take advantage of the existing law. Is that, but we're not changing the existing law in the bill.
Well, but what you're saying is you're going to award the fees on 2993.
Sure, that's the current law that we're not changing.
Okay, but you have to have abuse and neglect in that. In 2993, if you
Okay.
really study that, you have to have abuse and neglect. That's just like the attorneys that are collecting on my husband's estate right now. They're going under 2993. There
And
was
I hear him
no.
just say that's not part of this bill. I just want to point that out. It's not in this bill.
But it says that's how their fees are going to be paid. It clearly says that.
Okay.
So if you're going to, so in other words, how are you going to approve this abuse and neglect of in other words, like in my case, the attorneys got their fees on 2993 when there was no abuse and neglect. So
Okay.
that's what I'm saying.
I understand. Okay. Any other questions from the committee? Thank y'all. All right. Chairman Leverett, come close this out, and then we will see what the committee wants to do.
Thank you, Mr. Chairman. Very quick close. I feel that much of the opposition to what we're doing conflates the evaluation with the finding made by a judge, not by an evaluator, of the need for a guardianship or a conservatorship. This is merely one piece of evidence that is needed to allow the case to proceed. If the case does proceed, then an attorney is appointed. If the proposed ward doesn't have one, sometimes a guardian ad litem is also appointed, and the judge makes a decision after an adversarial hearing where the proposed ward or their attorney can question the petitioners, can question all the evidence, and although I believe it already is currently permitted implicitly by law, I've tried to enshrine explicitly the right of the proposed ward to do just that, to challenge the qualifications of someone, even if they're statutorily qualified. They can challenge the experience, the abilities, and the capacity of this person to provide an evaluation or whatever the result.
Can I ask you a question? So, the way it works now, a proposed ward has a right to counsel, and so they either, I'm asking, can they hire a lawyer, or is one appointed for them, kind of like an indigent defendant? Either way, is that how it works?
In my experience, I just did one of these about
Judges
a year
are
or two
nodding.
ago. In that
Okay.
case, the ward was able to retain their own counsel. But in other cases where they have not, the court will appoint
But
counsel.
by law says they have to have counsel.
They do.
And so when we have, and that was the reason I'm asking that, on line 113, for example, the proposed ward's legal counsel may challenge, we don't say proposed ward because they have a counsel by law for
That's
themselves.
correct.
So that does allow, in your bill, would create a new way to at least to challenge these individuals that are doing the evaluation.
It does, Mr. Chairman.
It's always been that way.
It's been that way, but I'm trying to enshrine that and
You're
confirm.
codifying it even though it's always been that way.
Because I think that's an important point that I think my friends raised.
Okay.
That I felt we ought to make sure people are aware they have that right and that courts
Right.
are aware of that, but I think most courts are. So I would just stress the evaluation doesn't end it. It just lets you get started. It is not the final decision. And as to the qualifications, we have just a fundamental disagreement. The statutory definition of marriage and family counseling talks about assessment of developmental disabilities and mental health. So while I don't know that they're qualified to diagnose mental illness, I do think they're qualified to provide an evaluation, which is something different from, even technically assessing capacity and certainly making some diagnosis or treatment for mental health. And I would just say, as to the testimony of the last two witnesses, they truly have had a horrible experience. I don't question that at all, but I don't believe that's a reason to do away with guardianships. But that's effectively what we're doing now by not allowing people to do the evaluation who are willing to do it. Right now, physicians and psychologists generally don't provide them. Licensed clinical social workers will on occasion, but it's just difficult for probate judges to find anybody to do these evaluations these days. And it's important that we allow the judge to pick the evaluator. I think that's a crucial issue. expanding these classifications to people that we believe are qualified will at least allow the judge to pick someone that's independent to do that evaluation, which to me is more important. It's probably one of the most important features of the legislation.
You have a question for Leader Jones.
I just wanted to clarify right quick. So that on line 114 where it has the legal counsel, that can be retained, but it also could be appointed too, is what you're saying?
Yes, yes,
they
sir.
will have legal counsel.
Yeah, if they haven't retained someone, the court's going to appoint for them. And the court may even appoint a guardian ad litem independently to do an investigation and report to the court.
Okay, all right, thanks.
So I just want to stress, this is not a summary, perfunctory proceeding.
Is a guardian always appointed automatically or just legal counsel automatically?
No, I would say these cases are at times dismissed. The ones I've done, which have just been in Superior Court, the probate court of Everett County, Judge Huell takes them very seriously. She gives a lot of time and attention to them, and she doesn't assume anything from your petition. She makes sure.
Let's get it right. Leader Hatchett.
Thank you, Mr. Chairman. So, just so we're all on the same page, or so I'm on the same page here, what you're doing here is essentially codifying the rights of the ward to challenge the sufficiency of the conclusions of the court. Is that
well,
accurate?
Of the evaluation.
Of the evaluation.
Yes. And of course, they have the right to challenge the conclusion of court through appeal processes. But in the hearing itself, I'm trying to just give express confirming codification to two things. One, that a developmental disability is not in itself a reason to grant a guardianship or conservatorship. I think that's already understood, but I wanted to make doggone sure it was understood and that it's law. Secondly, I've got 2 or 3 provisions, and they repeat. They apply in the guardianship, and then they repeat in conservatorship. That makes it clear that the ward can challenge about anything about the evaluation that they think is relevant to challenge. Because I think it's important they have the right to do that. I guess, in a way, I'm trying to take our debate tonight and say, well, that's a valid debate to have, but let's have it during each independent case based on the particular qualities of the evaluation and the evaluator.
And, Mr. Chairman, if I can, so essentially, although you said I know this happens in practice, what we're doing is we're codifying those rights, so they will always have them, and they will have will always have the opportunity to challenge, I guess, the court if there is a determination.
Well, they have that right already. What I'm talking about is
at the
challenge the evidence that the court is considering before the court makes its determination.
I got it. Thank you.
Thank you for the question.
All right. Senator Parent.
Thank you, Mr. Chairman. Thanks, Representative Leverett. Question following up on the court-appointed legal counsel. Who is typically taking that on? Are these pro bono attorneys, people working pro bono, or is it folks who are otherwise volunteering within the system, or what?
I think that depends on the particular circuit. I know in our circuit there are some attorneys that the judge usually turns to. It's not intended to be pro bono. It frequently turns out.
They're paid hourly by the county. Is that how that works?
I don't know. Judge Wolk may be able to.
Ours get $125 per case.
All right, so there's
the ability to ask for extra compensation for cases that go on for weeks.
So they're paid $125 per case.
The attorneys are?
The attorneys are. Plus they may get some extra compensation if the case goes on longer after a hearing. Okay. All right, any other questions from the committee? All right, what's the pleasure of the committee? If there is a pleasure of the committee. All right, we do have a motion to pass by committee substitute from Leader Hatch. Is there a second? Second from Senator Rhett. Do we have any amendments? All those in favor of the motion to pass will raise their hand. It is unanimous. It's been a good discussion as we work through this. I know the work continues because the bill had to go back to the House. Who's going to carry the bill in the Senate?
Senator Watson.
Senator Watson. Okay. Thank you.
Thank you.
Thank you all for your work. Oh, yeah.
Oh, that's right.
Sam is here. I think he wants it.
Not Sam.
No, Sam Watson. Okay. Our newest member of the Judiciary Committee, Sam Watson, will take it. Thank you. Wait, I may have to carry that ethics bill if I do that. So, Ben Watson.
Thank you. And thank you to my friends for their engagement.
Thank you. Thank you all. Thank you for your work. The work continues. With that, we are officially adjourned. Sani Da. Thank you.